Hello, everybody, and welcome to History/Law Bite number 131, dated December 13th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Lochner versus New York, 198 U.S. 45, 1905. This is a very, very important case in American constitutional law, not for what was involved in the case per se, but for the very destructive effect it had, on legislation designed to protect workers in the arguably the first quarter of the 20th century. I'm sure you've heard of Lochner versus New York, either in a passing sense or maybe in your constitutional law class in high school or college, grad school, or even law school, But, Lochner versus New York, if you have not heard of it, is one of the most absolutely asinine decisions ever decided by the U.S. Supreme Court. One that, although it has never been overruled officially, has been virtually abandoned, as a matter of principle in constitutional law. So if you've never heard of this case, you're in the right place. So, what exactly happened in Lochner versus New York? Well, in the late 1890s, the state of New York enacted a law limiting the amount of hours bakers could work in a given day and in a given week. The owner of a local bakery in Utica, a Mr. Lochner, was opposed to such restrictions between him and his employees, the amount of hours that he decided was best for his employees. And according to him, that his employees wanted to work as well. All right? So Mr. Lochner would eventually be fined not once, but twice for violation of the New York state law. He paid the fine the first time without issue, but the second time he challenged it, losing on all levels of the New York state court system. When the matter was eventually appealed to the Supreme Court of the United States, Lochner's attorneys argued that New York's law unconstitutionally violated the freedom to contract protected by the 14th Amendment's Due Process Clause, an inherent liberty guaranteed by that clause, the freedom to contract, in this case, between the business and the employees, Essentially, a fundamental protection more for businesses than employees, needless to say. A fundamental right to do business as one sees fit, And laws essentially abridging that were unconstitutional according to Lochner and his attorney. So, the respondent, the state of New York, argued that the state itself had more than enough power in its inherent policing authorities to regulate, the health and safety of workers in the state. It was an inherent part of states' police powers to do this, And there was no so-called fundamental protection for the right of businesses to do business any way they saw fit. Businesses did not have the right to subject to their employees to unhealthy and unsafe conditions, which is essentially what, according to New York, Lochner was advocating for. And so thus, the Supreme Court was presented with a fairly simple question. Did New York's law limiting the amount of hours bakers could work in a given day and a given week violate the right to freedom of contract as protected by the 14th Amendment's Due Process Clause? In a not surprising 5-4 decision written by Justice Rufus Peckham, the court ruled that New York's law indeed was unconstitutional, as it violated, and I quote, the right and liberty of the individual to contract as protected by the 14th Amendment's Due Process Clause. This is essentially a substantive due process right that the court carved out of the 14th Amendment's Due Process Clause. No such right is clearly enumerated in the Constitution. All right, this is a right that my most wonderful professor described many years ago as completely made up by the court. And indeed, in my opinion, he was absolutely correct in that assertion. The Supreme Court intentionally made this right up as a means to protect the ability of businesses against, quote unquote, unjust regulation by the states. All right? And because New York's law, which had the intent of protecting the health and safety of workers, wasn't really doing anything, because the petitioner here, Lochner, presented that bakers aren't in a dangerous occupation. Okay, they don't need laws protecting their health and safety. All right, so they don't need limitations on the amount of hours they can work, according to Lochner. All right, and the court bought this hook, line, and sinker and ruled that because of that, New York's law is not doing anything and was an unjust and arbitrary exercise of state power against a protected constitutional right to freely contract. They ruled that the right to freedom of contract was one that was deeply rooted in American history and tradition. And while the ability to contract is indeed deeply rooted, guess what else is also deeply rooted? Limitations on what businesses can do. But the court didn't pay attention to that. That wasn't something that needed to be brought up, as it would significantly undermine their faulty logic in upholding striking down New York's law. Okay, incredibly faulty logic. All right. So thus, New York's law was unconstitutionally enacted. All right, because the health of bakers was not in question, because what bakers do, according to Lochner and his attorney, was so safe that New York's laws limiting the amount of hours that bakers could work, okay, was absolutely unnecessary. Bakers could work as much as they wished because baking is such a safe occupation. So New York's law was thus unconstitutional, violating the right to freedom to contract as protected by the 14th Amendment's Due Process Clause, a substantive guarantee of liberty. Okay? So, but obviously everyone on the court didn't go along with this. Two justices, Justice John Marshall Harlan and Oliver Wendell Holmes, wrote scathing dissents to the majority opinion. Justice Harlan advocated the principle here that the Supreme Court essentially only had the authority to review such legislation if it was enacted, at least in theory, to protect the health and public safety of the people, but had no real relation to doing that very thing. And thus, also, the law would have needed to be a clear invasion of some clear fundamental right. Okay. Harlan also advocated the position that the burden of proof should be on the party challenging the law itself, not the state to prove that its law was meeting a substantial interest. Okay. That position would later be adopted in other cases sometime down the road. All right. And Justice Oliver Wendell Holmes' dissent, this is one of the most famous dissents in history. He wrote that, quote, "The 14th Amendment does not enact Mr. Herbert Spencer's social statics." All right. Therefore, all right, Oliver Wendell Holmes stated that a constitution is not intended to embody a particular economic theory. All right. And that's a powerful statement. It's not. All right. And the irony here is that Holmes was a huge supporter of laissez-faire economics. Laissez-faire meaning, hands off, get away, complete total lack of regulation. Businesses and means of production are completely unregulated by the government or anything else. All right. And so they can do whatever they want. Holmes was a believer in laissez-faire economics, but Holmes was also very deferential to the will of legislative bodies, democratically elected legislative bodies, to pass laws on behalf of their people. All right. So Holmes was very, very reluctant to strike down state laws unless they clearly violated some specific part of the Constitution, which New York's law did not, under any logical or feasible reading. of the Constitution. The majority's faulty logic, indeed, has been ridiculed since that time. All right? So, again, the essential holding in Lochner was that New York's law limiting the amount of hours bakers could work in a given day and in a given week was unconstitutional, as it violated the right to freedom of contract, the ability of freedom to contract, as protected by the 14th Amendment's Due Process Clause, a right that was theoretically deeply rooted in American history and tradition. All right? It was a substantive due process right, as described by the court, protected against unjust invasion by the states. Okay? Interestingly enough, Lochner was not the first case where the court asserted that freedom of contract, and freedom to contract, was protected as a constitutional right. That actually happened some 8 years earlier in the case of Algier versus Louisiana in 1897, a case that most people have never heard of. But that case hardly got the attention that Lochner has, because in Algier, what was at issue was out-of-state insurance companies doing business in another state, whereas Lochner involved the health and safety of workers. So obviously Lochner has a much more realistic effect to the average individual than out-of-state insurance companies. All right. So between this, Lochner versus New York, thus issued in the real Lochner era, all right, as it is known, although it officially began with Algier versus Louisiana in 1897. So between 1897 and 1937, the court struck down about 159 federal and state laws inhibiting the right to freedom to contract, okay, as they were perceived to be in violation of the 14th Amendment's due process and equal protection clauses with respect to the states, and with respect to the federal government, the Fifth Amendment's due process clause. So the court was just applying this made-up doctrine to the states and the federal government litany of different times, all right? But their jurisprudence here was very inconsistent. Some laws were upheld, many more were struck down, all right? Excuse me. So, the Lochner era was a very, very testy one in American history, okay? States, were hard pressed to protect their workers and others with respect to these laws, because they likely viewed them as constitutionally suspect based on the Supreme Court's logic during the period of 1897 through 1937, okay? And it arguably reached its peak in the 1930s when the court invalidated several New Deal measures, okay, designed to protect the people and lift America out of the Depression, all right? The Lochner era essentially came to an end in 1937 with the case of West Coast Hotel versus Parrish, all right? And it met its official end, the end of economic substantive due process, okay, with the case of Williamson versus Lee Optical of Oklahoma in 1955, okay? So that was the end of economic substantive due process, not the end of substantive due process. Believe me, the court still uses that, but economic substantive due process, when they use substantive due process to protect economic legislation, that era, thankfully, has come to a close, as they realized, better late than never, that laws were most certainly needed to protect the workers from employers, all right, ensure safe and healthy workplaces, regulation on hours, regulation on wages, and a litany of other things. These laws were essential powers of the states to bring into existence, okay? The state had inherent authority to protect the people from unjust treatment by businesses, all right? And that included whether a consumer or an employee, all right? States had the inherent right, and federal government had that right as well, all right? So the court didn't continue to invalidate these laws, all right, as a general rule anymore after 1955, merely because it disagreed with the law per se, as it practically had done from 1897 all the way until 1937. But Lochner was essentially the real deal case that brought the economic substantive due process argument out in full force. All right. So like I said, Lochner's very vilified decision, and there's almost universal consensus these days that it is one of the Supreme Court's most horrible decisions ever decided. Okay. As it, for more than a generation, arguably inhibited the ability of states and the federal government to enact regulations designed to protect the most vulnerable people from unjust treatment by businesses. All right. So that's Lochner versus New York. All right. And again, the citation is 198 U.S. 45, 1905. All right. Lochner, again, has never officially been overruled, but its essential holding has been entirely abandoned as a principle in U.S. constitutional law. Any questions or controversies about this decision, leave them down below and I'll answer them. If you have not subscribed to my YouTube page, just hit that little red subscribe button and that bell, and we are in business. I thank you so much for listening to this about Lochner versus New York. It's a very interesting case. You learn a lot from it. All right. So continue to tune in to these History and Law Bites. I would greatly appreciate it. Thank you again for listening. Take care. Stay safe out there. And I'll talk to you at the next bite. Peace.